job for judges, no matter how elevated, is to read what the law actually says. And Your Honor, I'll note that litigants often don't have access to this information. We did not become aware of the whole timing issue. Pursued a Public Information Act request. I couldn't rely on that, so I did my own Public Information Act request, never having had an inkling that there was a reason to suspect the timing was off. But once I got the response, I saw this did not comply with the statute. But litigants aren't going to generally go through these steps when they have an assigned judge. And Your Honor, I'll note that the letter that Justice had sent, the Chief Justice had sent, it has a nice sentence about, it's directed to Deborah, who's Deborah Evans, but there's no way in the face of that two-sentence letter to not assume it's a form letter, not that he did some analysis. And of course, because there is this advice out there from an agency, there is a potential here. This becomes a significant problem for the jurisprudence of Texas. But I don't know of any law that would say an agency's advisory opinion about how to do something should ever trump unambiguous text. And Your Honor, if I may, this issue has gotten more complicated since our briefing. I have given a copy of In Re Gary David Green to opposing counsel. It's a decision for the CCA from October 9th. May I approach?
You may.
It's a very short order in the mandamus proceeding that involves whether or not a party has a right to object to an assignment of a retired judge. And this is a huge issue. The state of Texas, in this other jurisdiction, is arguing they had a right to object to an assignment. What that implies, quite obviously, is they had a right to notice, too, when a judge was assigned. That is another complexifying, that's a word, problem in this case, is that Your Honor's assignment of Judge Evans was made on November 16, 2023. We, however, did not receive notice of this document until it was attached to a proceeding by the state when they finally responded to our request for a hearing before an execution date was set. This was in June 20th, 2024. So months after the fact, we did this as an exhibit to their brief, even though the text of your order suggests that it should be served on the parties. And it has been known for years that I represent Mr. Roberson and how to find me, and who Mr. Roberson is and how to find him. This was not served on us. So if there is in fact a legal right, as the CCA is considering now, to object, we were deprived of that. So
Well, did you file an objection to Judge Evans in the time frame prescribed once you received notice?
what happened, Your Honor, is we didn't have, when she got assigned the case without our knowledge, there was no case.
I'm talking about when you got notice in June. Did you file any objections to Judge Evans?
We did not. What we filed was a motion to be heard.
I understand. You didn't file a motion you didn't file an objection to Judge Evans, if you had that.
If we had that right, which we were not aware of, and it's just now percolating in the courts, we did not obviously act on that. We were confused, but I did contact, I was not sure why they were treating her as the assigned judge. My understanding is she left the bench. And I think we get into the recusal issues. There are multiple reasons why it was troubling that she was being reassigned to the case. And that we had not gotten notice, and we were not being allowed in the courtroom. And I will say, I should have said this at the outset, Your Honor, we are exceedingly grateful that you allowed this hearing. This is our first hearing since we started moving for a hearing in April to try to prevent the setting of what we think is a travesty, the execution of a man who has robust evidence of actual innocence that no court has yet looked at. So we have been fighting to get into the courthouse, and this is our first chance. And we think that whole circumstance, which I will not go into now, is relevant to the recusal issue. But before we get to that,
To the motion debate.
and Your Honor is right, jurisdictional is fundamental. Our argument really boils down to, we say the text supports our argument, they say practice supports their argument, and Your Honor will make that election.
When we're talking about the judge and process of retirement and placement that they support, said exactly, the office of court administration warns all judges and the process of judge the process prior to their retirement. And consider, furthermore, clean reading the statute does not necessarily match up with what the statute itself, we talk about retirees, but the instruction for how to do this does not say retiree. It says not later than 90 days after the date of the person's retirement. First, furthermore, it doesn't preclude filing early. It just says you cannot file after the 90 day. Once it's after the 90 day, just explain the 2 cases presented to the court. Then it has to go to the full court for decisions whether or not they can approve it, and a whole different process goes into effect. This is just, she filed early, and there's nothing that precludes this, maybe, but there's no reason to favor it. She just probably responded.
Your Honor, that is a very strange reading of the statute. It says after the 90th day, after the date of the person's retirement. So only a person who is retired is a
Now
retired.
that's subsection 2. Subsection 1 is where the argument is that Judge Evans became a retired judge or senior judge under subsection 1. You were reading subsection 2.
Excuse me, Your Honor. Yes, it still says not later than the 90th day after the date of the person's retirement, and a document addressed to the Chief Justice. So you're right. So you're suggesting, the opposing counsel is suggesting, and I'm not arguing in their brief, that because it says person there and not retiree, this trumps the other language. It starts with a retiree may elect. You cannot elect until you have the status of a retiree.
Right. Court has considered case law, the arguments of counsel, read the motion. Under the circumstances, find that Judge Evans was properly appointed as a senior judge, that she did make her election no later than the 90th day after her retirement. She actually did so preemptively. And there is nothing in the law that would preclude that. Further, Chief Justice Heck's letter to her says it would be effective on her retirement date. Therefore, the motion to vacate is denied. We will now move towards the motion to recuse. I will also note for the record that the defendant, Mr. Roberson, is present via Zoom.
Thank you, Your Honor.
All right, we may now proceed with the motion to recuse.
Your Honor, as you know, moving to recuse a judge is a fraught and difficult issue. There has been a suggestion by the state that we somehow waited opportunistically to do this 3 weeks before an execution. And that is a false representation in the history. And it is also a false representation to suggest that only after 7 years of her litigating the case, we are now complaining. I will say on the record, I believe Judge Evans is a very smart woman. That is one reason. It was stunning to me when her findings issued in the habeas proceeding days in this very courtroom and several years of litigation to bring evidence, including 6 highly qualified experts. We overwhelmingly satisfied our burden under Texas's trailblazing junk science law called Article 11073, as well as under state and federal law. A new record was created, 13 volumes, thousands of pages. We submitted proposed findings, which are among the exhibits to our motion. The state submitted proposed findings. You compare those 2 documents, on its face, it suggests something is terribly wrong. The state's proposal, we contend, and we have raised this in previous filings, has gross omissions. It simply does not identify most of the evidence. And yet, as officers of the court, they had an obligation to honestly provide a summary of what had gone on in this case. Instead, it is grossly misleading. The few references made to any of our witnesses are inaccurate. They attribute out-of-context statements, and this is like 2 or 3 statements to a few experts, something they said on cross that doesn't even match how they characterize it in the findings. So I have never seen anything like this. I do principally death penalty work. Death penalty work involves the most serious consequence, as is self-evident. So for a representative of the state to misrepresent what had gone on in years of litigation was shocking. But I thought the contrast was obvious, as was the record. But regrettably, Judge Evans essentially adopted verbatim the state's grossly misrepresentation of what had happened, making very few little changes. One of them was conceding that the doctor who performed the autopsy had in fact testified about shaking, which the state was trying to bury. They were trying to turn the entire shaken baby case into a case about battery, when we had just demonstrated overwhelmingly there is no evidence of a battery. This is a classic shaken baby case, as its experts said at trial, as prosecutors said. The battery language at trial was completely irresponsible, untethered to evidence, and based on the admissions of that pathologist, cannot withstand any scrutiny. But they were taking this position, wasn't a shaken baby case, but even if it was, shaken baby science is fine, and then I would. Judge Robbins, of course, as a district court judge, had no power to say no to trial, but she had extraordinary power to frame for the higher court what the truth was. And she did not, in this moment, do her job. And it was inexplicable. And I will say, I have great respect for how she conducted herself. It was one of the heartbreaks of my own professional life, not to lose, but to have a jurist behave in this manner when a man's life is at stake, and a man's life who is innocent of the crime for which he was convicted. So she denies all the evidence. It's not mentioned. Denies that we should get relief, and that goes up to the CCA.
And the Court of Criminal Appeals on October the 10th denied they denied your all's petition, did they not?
What the Court of Appeals did is refuse to consider it. And they didn't even issue a written decision.
Well, there was a concurrent opinion.
There's a concurring opinion, which we have now responded to, Your Honor, with a subsequent writ application.
And I see that, but again, under the rules of procedure Rule 18A and B, the rulings of the court in and of themselves are not sufficient grounds for recusal.
Correct, Your Honor. That is a fundamental component of recusal law. But I'm just trying to talk about the timeline. I have no reason, though it is hard. We're in a rural county where, of course, people know each other in the community. the trial prosecutor, one of the two members of the trial prosecutorial team is one of the sitting judges here in Anderson County, which is a very painful situation. But we did not have evidence, and hint that there was a problem with Judge Evans' ability, potentially, to act in an impartial manner until she retires. And she retired, well, until she issued these findings that were completely out of whack with the record, and then announces her retirement and is gone. Then we have no case pending. But somehow, behind the scenes, and we don't know the facts here, but we know it's behind the scenes, and we know it's uncontested, and we're not given notice, somehow she gets assigned. And that in itself adds another factor to the recusal puzzle. Why is a retired judge wanting to reach in and participate in a death penalty case that has been highly contentious? And why was there no notice to the defense when we would have had a chance potentially to object? That's the legal issue right now before the CCA until last week.
But again, even if you thought you had grounds to object, you did not object in the time frame prescribed to an objection for a judge once you received notice.
And Your Honor, I will say that is absolutely true because we had no inkling under the current law that we had a right to an objection. This decision, and I shouldn't say decision, this mandamus proceeding is the first time it's been litigated because the other side of this argument, the habeas applicant, which is the Office of Capital and Forensic Risk, they're suggesting you don't have a right to object in a criminal case. So it's not a settled issue. Certainly we had no way of knowing we had a right to object, but we now know it's something the state is claiming. And that adds to the due process problems of the failure to provide us with notice. So we didn't get notice, and we don't have any reason to believe she's going to be the judge when an execution date is set. When we filed in April our motion for notice and opportunity to be heard. That motion arose from the fact that the elected DA conveyed to a member of our team that she intended to seek an execution date. We were alarmed by this because we had overwhelming additional new evidence that no crime occurred. We apprised her of the intention to file a subsequent habeas application with yet more new evidence. And this evidence, I will point out, was to respond to their two witnesses in the previous habeas proceeding. Where Judge Evans had said, I'm going with the state's two witnesses. I'm not even going to mention what the testimony was from the applicant's 11 witnesses, including 6 experts. So those findings led us to do due diligence and say, did this child really have pneumonia? Did this child really have toxic medications in her system? Who are the experts that know those things? So we apprised opposing counsel of this intention, but we don't get a hearing, and that's odd. I don't know.
But is a hearing required?
It's not required, but it is commonplace.
I understand that some courts grant those, some courts don't grant those. Is that correct?
I would say on the civil side, where I spent a lot of time, anytime there's a contested issue and a party requests a motion, they get a hearing. It seems very odd to me when you're dealing with matters of literal life and death that there would be no basic due process right. And certainly the Supreme Court has said that in any matter, including any state matter, there attaches that fundamental due process right to be heard. So, yes, Your Honor, under the U.S. Constitution, at least under the 14th Amendment, there is a right. But why would it be when you're fighting about money or who's over the property line to get a hearing, but when about setting an execution date, no? This was odd.
I disagree with you that all the civil hearings you get, civil matters you get a hearing because there are many things many judges, including myself, take by submission rather than here, having hearings.
And Your Honor is correct. In the federal system, that is the norm. But in my own practice of over 20 years, whenever I have noticed a request for a hearing, I've gotten a hearing. Here, I wasn't even aware who the judge was. I was asking, I was confused why they were acting like it was Judge Evans. It wasn't until then the state filed a motion seeking execution date, we're now in June, that they attached then the assignment document we were discussing earlier, Your Honor, setting off two panics. It's like, oh, we have Judge Evans, and that's an issue. We've been having these concerns, and now we have an execution date.
And if you have those concerns, why wait? If you're aware of Judge Evans' assignment in June, why wait until September 25th to file your motion to recuse?
Again, Your Honor, because recusal is so fraught, and I would say in my own experience, hard to accomplish, that one does not want to pop off and file a motion to recuse. And so,
And I understand that, but also don't the rules dictate that you should file your motion as soon as practicable once you are aware of the circumstances that, in your opinion, would justify recusal?
that is absolutely correct, Your Honor, but we weren't that aware. We were aware it was a cumulative development. It would not have been right, as Your Honor pointed out at the beginning, to bring a recusal motion simply based on Judge Evans' rulings. But what comes out is that a judge who was not literally connected to the trial's case has these deep, long-standing personal connections with many people who have been involved in affecting Mr. Roberson's fate, including, I mentioned, the Honorable Mark Calhoun, who was one of the prosecutors, is now a judge here in this courthouse. The elected DA, Allison Mitchell, who was in the DA's office when this case was tried, who had presided over the habeas, litigated the habeas proceeding. But then it was judges involved in the underlying custody battle over this child, who is the subject of Mr. Roberson's death sentence, his daughter. There was a fight over who would have custody of this child that did not involve Robert. Judges were making rulings, all of whom, it turns out, Judge Evans has long-standing relationships with. But this is again, and that included making determinations to eliminate Robert's parental rights and give control over how his daughter's body should be disposed of after she was taken off life support. So this is not lighthearted, minor matters. These were people who made profound decisions that affected Mr. Roberson in an adverse way related to his conviction and his rights and relationship with his own daughter. Again, those decisions were made. We had already been accused and thrown in jail for capital murder, which we claim to commit. So here's another area. But then we learned that Judge Evans' son had, for a short time, been hired by DA Mitchell. He was a civil lawyer. He gets hired to come in and help her try a case, seemingly so he could say, I have a criminal trial under my belt. And then he goes and runs for county attorney in a nearby county. And it just caused huge problems because that other county was where Judge Evans also was a sitting judge. Lots of conflict problems. And the thing that we became aware of later is that there was a challenge in a habeas proceeding to the fact that that trial, that one and only trial involving her son, she presided and did not disclose on the record this relationship. And this isn't about something that the defendant can waive. In the language of the statute, this is absolute. It's a disqualifying fact. So this seemed to me another variable that Judge Evans doesn't always play by the rules, particularly when it comes to habeas proceedings involving unpopular indigent people. But then it turns out there's another case that has implications here. This ex parte Castle case, which turns out to be another shaken baby case, tried here in Anderson County, I believe in 2014. We had no awareness of this. We accidentally become aware, and it also becomes clear that somehow Judge Evans had gotten assigned to this case, again without public disclosures, and had...
Are you in some way suggesting Judge Evans went and sought this case?
I don't know, Your Honor, and the only...
Is it perhaps just as likely that it was randomly assigned to her, just like the way all cases are assigned in Anderson County?
It could be, Your Honor, except...
Well, okay, but if you don't have any evidence to suggest that, it's disparaging on Judge Evans without any evidence.
And Your Honor, I can see that this is why it is so fraught to bring a recusal motion, because one doesn't always have the best evidence. But what we have is a letter she issued to counsel in that case on letterhead, official letterhead from the 87th District Court, as if she were the presiding judge. And she wasn't. This was after retirement. And it's by sheer accident. I happen to know counsel on that case and asked who their judge was because this was another shaken baby case in Anderson County. What a coincidence. And she was confused. She didn't have no idea that this was an assigned judge. She didn't know she was retired. Then what happens is that Judge Evans in that case denies all funding to the habeas applicant in a very sophisticated shaken baby case. No expert funding, no funding for investigation. That led to a mandamus proceeding. This becomes another sign that there's some appearance of a lack of impartiality when it comes to these shaken baby cases, particular kind of configurations. Because I must say, Your Honor, we are not accusing Judge Evans of being biased. We don't know that. All we can do is look at the evidence and say an objective member of the public viewing these things would reasonably conclude there's a lack of impartiality. That's the standard, and we believe we've more than satisfied the standard. It's not just about the rulings that went against us. It's the lack of transparency in the process itself, how she even came to be assigned, about the lack of transparency and seeming inadvertent, perhaps, deception about being assigned judge in another shaken baby case. The rulings in that case that make little sense when the CCA had authorized for further factual development in that case. And then there's the human element. We all have relationships with people that make it very hard for us to be objective when their work is being questioned. And fundamentally, this case has been about the science, how the science that was used to convict Mr. Roberson has changed so significantly that the vast majority of what his jury was told about science was simply false. And then there's this shift to try to turn it into a battery case, reflected in that recent concurrence you mentioned from Judge Erie. There is no way, if Judge Erie were familiar with the actual record, he could have written that concurrence. That concurrence reflects a reliance on Judge Evans' false representation of what the evidence was, which was essentially drafted by state's counsel with some minor changes. So the CCA has been misled about this case for years now, and that is the first time we've gotten any indication of what the problem is. The problem is they have a belief about this case that absolutely does not withstand scrutiny. They describe this crazy battery that nobody saw, and there's no evidence to support it. The child had no significant bruises, no abrasions. She had one minor to her head. In this courtroom, the pathologist who did this autopsy 20 plus years ago pointed to the top of the head as a sign of some second impact site. Yet we developed in this courtroom the evidence that that was where the hospital had surgically affixed a pressure monitor, screwed it into the skull of this child when she was on life support, and then taken it out, and thus caused bleeding and bruising. None of that existed when this child was brought to the hospital. None of that is evidence of a blow she received. Likewise, the issue of a minor torn frenulum inside this child's mouth didn't exist when she was brought to the hospital.
I think you're getting outside the purpose of a motion to recuse, and I want to stick to the legal grounds that you have to suggest that there should be recused. And again, as far as her rulings on what the rulings she's made throughout this case, those in and of itself are not sufficient for recusal.
Your Honor is absolutely correct, and again, the language of the statute is it can't be the rulings alone. And we have brought before robust evidence of multiple variables, and the law is clear, you have to look at the totality. And what the state did, first of all, they disregarded several things we mentioned, but then they took one at a time. They said it's only about our rulings. Well, if it were this is not right. If it's this, it's not. You can't do that. You have to look at the totality. And that is the grounds in the statute that we're not here to prove she is biased. We're here to prove and let me read the language, I don't mess it up. That this is Rule 18B sub B, that she must be recused if her impartiality might reasonably be questioned. And it's, again, the case law that Your Honor is probably very familiar with. The burden of proof is on us, but it's not about proving she is biased. It is also tied to a federal standard. Again, this is a constitutional issue about the fundamental fairness of the tribunal. There are Supreme Court cases where it was held that a judge should have been recused simply by signing some paperwork when in the DA's office that then is part of a case that later came before that judge. That's right. The Supreme Court.
Now, I'm aware of that, because when you actively participate as an attorney in a case, and then later that case is in your court as a judge, you are recused from that. That's automatic. That's disqualification, actually, not even recused.
Correct. And that's why also disqualification is when a close personal relative comes before you as counsel. You are not allowed to preside over that.
Right, but that did not occur in this case. That occurred in another case.
In another case. But that's part of the evidence we brought to Your Honor. Because we can't just talk about the rulings of the case. So we brought you other evidence that, if looked at objectively, suggests Judge Evans is not the right person for this case. And the way, particularly, we have been denied a hearing over and over, trying to prevent the setting of an execution date, and then trying to get it withdrawn. And that's the last point I'd like to make, Your Honor. We filed a motion to withdraw the execution date after we had filed a new subsequent habeas application. That is a statutory basis for a district court to withdraw a date. They don't have to, but they may. And we were not allowed a hearing on that issue. So we proved we asked for it to try to avoid the setting of the date, we didn't get it. Then after we did our filing, that's part of the explanation of why we didn't move to the accused. We were struggling to protect our client under threat of execution. So we're doing all this, developing our new claims, this massive amount of new evidence, when we get more experts, specialized in lung pathology, etc. We did not yet feel confident. And I will disclose, there was a debate among counsel. But I was shot down, told this would not be, we don't have enough information to suggest there's a lack of impartiality from the perspective of the public. But the way we were denied a hearing over and over, without a date, without even an entertainment of our objections, and then the state filed a misleading response. And this was another very depressing moment. The state argued that Judge Evans had no authority to withdraw the date, when Texas law plainly gives her that right. And they gave her cases, none of which they cited cases, that didn't support what they were telling her the law was. We filed a reply countering that legal argument, but also urging a hearing. Again, we were denied a hearing. We filed a motion to reconsider just that decision, attaching, I think it was over 20 samples of courts entering orders to withdraw execution dates under far less fraught circumstances after a hearing. But we weren't given the hearings, it was just a slam door. So this became part of the last straw. All this information about the Hassel case and the failure to just, acknowledge the disqualifying fact of our son before the same district attorney, and also the knowledge that they're friends. They traveled together. That would never be enough. But they were just friends with so many other people connected in this case. Of course it must be a challenge to behave in an impartial manner. And so we're urging, Your Honor, at this very 11th hour moment, to at least let us start over with any matter we may yet have before a judge who's not painfully implicated in the underlying facts. Thank you.
I'm trying to figure out where to begin, Your Honor. Let's start with some of the accusations towards Judge Evans. First, the first matter, which the Court of Appeals did review and found that there's no error in notice. Nothing was done in that case. She only has to accuse of someone who raised the issue, and the defendant knew that she was the judge. The defendant wanted the trial, wanted to see, only to get it, that paper that was left, the judge should prevail, was how Judge Evans here in the case, and she did. The address also is Ryan Evans, who reported to us in one case. He reported to us for 2 years. He had multiple cases. That is unsettled. Part of the case in the court of our office is not a matter of refusal, it's qualification. The facts of the matter, all the rulings do not apply, they're not to be considered. Let's add, every ruling she's pointed out has been reviewed by the Court of Appeals. That secondary bit, that she didn't withdraw the execution date, she has the ability to see if the Court of Appeals is going to hear a bit, and we're going to say, the Court of Appeals is going to hear it, and we're going to say, talking about other cases, all of this is just an attempt to scare a judge, scare our office, get the bill. That's what this means. She's done nothing but recusal, disqualification, in any way, shape, or form. Other things she points out are just different things that delegate small jurisdiction or our jurisdiction. Judges have heard cases that were prosecuted by the district attorney's office that they previously worked for their counsel. The judge is determined to be impartial. And that's proven evidence. And there was no proof in this case in any way that Judge Evans has done anything to besmirch her honor and position of judge.
Rebuttal argument?
Yes, Your Honor. A couple of misrepresentations, if I heard counsel correctly. State argument rulings are not to be considered. That is false. The law, as Your Honor articulated it, is that it can't be based on the rulings alone. One would have almost no argument in any refusal if it wasn't partly to explain rulings that made no sense. In my experience, legitimate requests for refusal come from being perplexed by a seeming lack of fairness. And that is the fundamental problem here, that the first indication we had of that, which is in Snowball, were these findings that were so terribly.
And what were these findings?
These are the findings in the 03 writ proceeding, summarizing what had happened in years of litigation. Our summary.
And again, so you're aware at that point that there's these rulings, yet you do not file your motion to recuse until September 25th of this year, less than a month before the scheduled execution.
And Your Honor, that's not uncommon, but let me point out, her rulings came on February 14, 2022. She then announced, I think she already announced she was retiring. So at that point, we think our experience with Judge Evans is over. We had no reason to move to recuse, and it can only have been based on her ruling.
But again, by June of this year, you are at least aware that she has been assigned to this case.
Right, Your Honor, and we were not aware how that happened. We were not aware of the jurisdictional issue. All we were aware is now the clock was ticking with an execution date, which we thought should never have been set, and that we weren't allowed for months to get information about who was the judge and why we were trying to get a hearing. You know, the judge has to decide, we don't even know who the judge is.
Okay, well, when did you start trying to get it?
And on April 9th, 2024,
Okay,
we
but
filed a
by
motion.
June, you knew who the judge was.
When the state filed on June 17th, for the first time we saw the assignment document, which had been served on the state, obviously, not filed, but a file stamp. That's the first time we learned of that.
Okay, just for the record, Judge Evans was assigned to this case as a senior judge on November 16th, 2023.
Yes, Your Honor, and that is one of our exhibits. But my argument is, we didn't learn of this, we're not served with your order until the state attached it to an opposition brief. And that raised yet another concern about due process. Why was the state informed of a non-filed order, but we did not?
The order was filed. The order was filed November 17th, 2023 at 10:43 a.m. here in Anderson County.
It's not in the public record, Your Honor. You signed it, you may have intended that.
That, we have to take it to the clerk's office, but I believe everything I've seen, it's in the public record. I have a file stamp copy.
I do not, and I will never serve you. As an officer of the court, I will tell you, the first time I learned of this is on June 17th. And that raised another red flag. But the council also misrepresented this notion that all these motions we've made, seeking a hearing, seeking to have a date set only after a hearing, seeking to have the date withdrawn. None of these are appealable orders. The CCA is not ruled on any of this. That's a completely inaccurate statement. What the CCA has done is continue to deny our next subsequent red based on all this new evidence without a written order. It's just happened recently. And then the state relies on that to try to suggest the merits have been disposed of. But the one sentence order says the merits were not considered. It was procedurally barred for a reason that was not explained. So that's a misrepresentation. And then to suggest, I think there's something about that all we're doing is trying to make work for their office. We have been working round the clock to try to save a man we think is innocent, working with multiple experts. And what the world is seeing is that Texas is barreling towards a terrible travesty of justice. But the Court of Criminal Appeals relied on a judge who, for whatever reason, and there are lots of reasons to imply a lack of impartiality, but her rulings can only be explained if there is an implicit bias towards the state where she has all these deep relationships with judges who have been involved in this matter, Judge Orleans, Judge Bentley, Judge Parsons, Judge Calhoun, and of course the elected DA, Allison Mitchell, who hired her son and with whom she's traveled. I mean, all of these relationships are with people who have been involved in holding on to conviction that we think has been greater than protected. So it's not like, oh, we just came up with this idea 3 weeks ago. We waited until it was overwhelming, the evidence of lack of impartiality and honor. And how bad would it have been to set a hearing in a case where you're going to execute a man who's going to use? What on earth is a rational explanation? The only way to understand it is a lack of impartiality. So we urge you, you denied the motion to vacate. We urge you to simply decide that you have the power to do right this minute, it's in your order, to just take that authority away. You don't even have to recuse her. You can just revoke the assignment and assign a judge who doesn't have the same personal, professional animus against this case.
Excuse me, a few moments.